Welcome to the Deep Dive. This is your briefing room, really for essential knowledge. When the Texas legislature drops hundreds of bills and the courts issue these major rulings, it's more than just noise. It means immediate operational shifts for you out on the street or in investigations. So today, our mission is simple. Cut through all that noise. We're giving you, the learner, a concise, high-value breakdown. We're covering the critical TCOE updates, the penal code shifts, CCP changes, and those operational procedures you need to know. Most of these hit the books September 1, 2025, but not all of them.
That date, September 1st, it's definitely key. But let's be really clear. This isn't just about looking ahead to next year. Yes, we have huge legislative changes coming. Absolutely. But we've also got two precedent-setting case law rulings that are effective right now, as in today.
Right now. That's critical.
It really is. These rulings, they fundamentally change how you handle affidavit swearing. Constitutionally required changes. And they completely redefine how you approach electronic harassment cases. So if you process a warrant this afternoon or you take an online harassment report tomorrow, you need to know this stuff immediately, or you risk having your case tossed.
Absolutely. Think of this session as like your procedural protection plan. We're hitting everything. How you investigate, how you interact with certain people, how you make arrests, and maybe most dramatically, how you deal with vehicles bought starting this July. That's a big one.
Right. Our mission today is simple. Make sure you are instantly prepared for these really critical legal shifts, the ones affecting your day-to-day duties. We'll dig deep into what these laws actually mean on the ground operationally, so the integrity, the viability of your next case stays solid.
Okay, let's get started. Let's begin with the foundation. TCOE mandates. And those critical immediate case law changes that, like you said, are already impacting things out there. Texas keeps refining what it means to be a certified officer, and it looks like the focus is really on, specialized interaction and formal expertise.
Exactly. Starting September 1st, you definitely see that focus on vulnerable populations and specialized skills. Senate Bill 1563 is a perfect example. It sets up a mandatory training program for all county jailers, and it's specifically focused on how to interact with veterans who end up in the criminal justice system.
Okay, veterans specifically. Why that focus?
Well, it's basically a recognition that, the justice system sees a lot of veterans, and they might be dealing with things like PTSD, other mental health issues, maybe addiction tied to their service. So this training, it's designed to help jailers with de-escalation, with specialized assessment, getting them to the right resources within the jail setting. It's really about ensuring a more compassionate and effective approach for this specific group.
Makes sense. And then on the investigation side, there's a big change with polygraphs, Senate Bill 2180.
Yeah, this one significantly formalizes things. It really elevates the professional standard. If you're a peace officer conducting polygraph exams, and that means for hiring and for criminal cases, you now have to get formal training and certification through TCOA.
So no more just, having someone administer it without that specific TCOA cert.
Correct. TCOA is specifically required to make rules prohibiting officers from doing these exams without that proper certification. It standardizes the whole procedure, and it gives a much stronger legal basis for the validity of those tests when they're used.
We're also seeing new groups getting peace officer authority, right? Kind of broadening the scope across the state.
That's right, and it's notable where that expansion is happening. It's often in specialized areas. For instance, officers commissioned by the Health and Human Services Commission's OIG Office of Inspector General, they're now classified as peace officers under the CCP. That gives them clear authority for investigating fraud and abuse in HHS programs. And then you see it locally, too. Harris County Hospital District, they're now explicitly authorized to employ and commission their own peace officers. Also, defense-based development authorities. They can employ peace officers now for their port functions and facilities, basically ensuring security for those key economic hubs.
And there was a specific point about fire marshals in the bigger counties. Why did that need clarification?
Right, good point. Historically, fire investigators sometimes had limited law enforcement powers, but House Bill 775 clears it up for counties with 100,000 people or more. If a fire marshal or an investigator is acting like a peace officer, making arrests, getting warrants, that sort of thing, they must hold a permanent TCOE peace officer license. It basically closes a potential loophole and ensures that professional standard for those high-level fire investigations in denser areas.
Okay, let's pivot now. You mentioned two critical case law changes that are effective right now. Let's hit the first one, the search warrant oath. This is the State v. Hardridge case from June 16th, 2025. You said this could invalidate warrants statewide if officers aren't careful. We really need to understand this one.
Yeah, this is huge. A procedural earthquake, really, for two reasons. What it requires, and the fact that the court shut down the usual good faith argument. So Hardridge. It involved a DWI arrest after reckless driving. The defendant refused a breath test, so the officer went for a blood draw warrant. Standard procedure, happens all the time.
Right.
The officer wrote up the affidavit, signed it, gave it to the magistrate, and the affidavit itself, it had the standard language saying the officer swore to the facts inside.
Okay, sounds normal so far. What was the fatal flaw?
The flaw was the officer never actually said anything, never verbally affirmed the oath, never raised their hand, never said, I swear.
Just sign the paper.
Just signed the paper and handed it over. And the court said unequivocally, just signing a document that has oath language on it, that's not enough. Not for the Fourth Amendment, not for the Texas Constitution. The requirement is that the officer has to formally swear to the truth of that affidavit, out loud. Before a qualified official, magistrate, notary, whoever, it has to be a verbal, formal affirmation.
Wow. So let me get this straight. If I walk up to a judge, sign my affidavit, hand it over, and they just stamp it, even if they think I swore to it by signing, that warrant is now bad.
Constitutionally defective. Yes, and here's the really tough part for cases. The court specifically said the good faith exception doesn't save the evidence here. They said the standard is objective. An objectively reasonable officer has to know whether they actually took a formal oath or not. If you didn't say the words, you didn't meet the standard. And that's not some subjective mistake that good faith can fix.
Okay. This means every single agency needs to, immediately tell their officers about this. Patrol, detectives, everyone. What's the absolute must-do step now?
The non-negotiable step is formal verbal affirmation, period. When you present that affidavit, you have to say the words, something like, I swear, or I affirm that the facts in this affidavit are true and correct to the best of my knowledge. And the magistrate or official needs to acknowledge that you said it.
Should departments maybe standardize the wording? Or have the judge initial something?
Absolutely recommend standardizing it. And yes, if possible, have the official sign or initial write on the affidavit confirming the oath was actually administered. If you're doing it remotely, digitally, you need some kind of verifiable audio or visual record that the oath happened. Don't just rely on the signature anymore. The oath isn't just paperwork, it's the constitutional bedrock of that warrant.
Okay, message received. Formal verbal oath is mandatory. Now, the second immediate change. Owens v. State, June 4th, 2025. This one changes electronic harassment investigations.
Yeah.
Penal Code 42.07A7.
You said the focus used to be on the nasty content of the messages. What did Owens do? Owens basically flipped the script. It threw out that content-focused approach. In that case, you had a guy harassing his former clinician. Lots of channels, texts, emails, fake accounts. Sent about 36 really hostile, profane, insulting messages over 15 weeks. He got convicted under the part of the law about repeated electronic communication meant to harass or offend.
Okay, sounds like harassment. But the conviction was overturned. Why?
Because the Court of Criminal Appeals said the law, as it was applied in that case, ended up punishing the offensive speech, the nasty words, the insults, rather than the conduct of harassing someone. They found it was unconstitutionally overbroad. It wasn't narrowly tailored enough. The First Amendment protects even vile offensive speech unless it's something specific like defamation or, crucially, a true threat. So if your case just rests on how insulting the words were, you're likely investigating based on an unconstitutional idea now.
Wow. Okay, so this is a huge shift for the officer taking the report. If I'm retraining my people, I need to tell them, stop just quoting the awful messages as your main evidence. What do they focus on?
You have to treat this as a conduct-based crime now, completely. The focus has to be on the pattern of behavior. What did the defendant do? And what was the verifiable impact on the victim? Your report needs to paint a clear picture of criminal conduct.
Can you give us a practical checklist? What should officers be documenting?
Sure. When you're documenting electronic harassment now under Owens, you need to meticulously establish 1, persistence and volume. How many messages exactly? Over what period? Was it 3 texts one afternoon, or was it 50 messages over 2 months? Document it. 2, timing and intrusion. When were they sent? Middle of the night, during work hours. Were they clearly disruptive? 3, evasion attempts. Did the victim try to block the person, mute them, change their number or accounts? And did the defendant then find other ways? Create new accounts, use someone else's phone. That shows persistence, that intent to keep targeting them. And 4, true threat. If there is threatening language, you now have to clearly articulate why it amounts to a true threat? Does it put a reasonable person in fear of imminent bodily injury or death? You have to explain that. So the bottom line is pretty simple. If your case boils down to, look how insulting these messages are, it's probably not going to fly anymore. But if your case shows a persistent, intrusive pattern of behavior that the defendant engaged in to cause distress, regardless of the exact words used, that meets the new constitutional standard. Focus on the actions.
Got it. Conduct over content. Okay, with those immediate case law bombs dealt with, let's move to the big statutory changes hitting in September 2025. Penal Code, Code of Criminal Procedure. Let's start with crimes against children and sexual offenses. Looks like some significant updates there.
Definitely. This area saw some really critical changes to definitions and victim rights. First up, the Summer-Willis Act, House Bill 3073. This amends the Maine sexual assault statute, PC 22.011. What it does is give a much clearer statutory definition of when consent is specifically lacking.
How does it change things for an investigator interviewing someone?
It really sharpens the focus on the actor's knowledge. The new language says consent is lacking if the actor knows the victim is unaware the assault is happening, or knows consent was withdrawn but keeps going anyway, or, and this is significant, knows the victim can't consent because they're intoxicated or impaired by any substance. So for investigators, your interviews now need to strongly focus on proving what the defendant knew or should have known about the victim's capacity or awareness. It gives solid legislative backing when the victim was incapacitated.
Okay, that's clear. We also see a change to continuous sexual abuse. PC 21.03, House Bill 1422.
Yes, and this is a crucial refinement. The new definition requires 2 or more acts of sexual abuse against 2 or more victims during a period of 30 days or more, and the actor has to be 17 or older. The older versions could apply to repeated abuse against just one victim. This update specifically targets those predators who abuse multiple victims around the same time. It elevates that specific pattern of predatory behavior to its own distinct, serious charge.
Makes sense. And, like we saw with the electronic harassment, the law is trying to catch up with technology. There were some strong responses to digital sex offenses, right?
Yeah.
Starting with invasive visual recording.
Yes, exactly. PC 21.15, House Bill 1465. This law clarifies what counts as a place in which a person has a reasonable expectation of privacy. It explicitly lists places like bathrooms, bedrooms, changing rooms, basically removes any argument about whether someone should expect privacy there. And significantly, if someone's convicted of this, they may be required to register as a sex offender. Add some serious teeth to violating privacy like that.
Okay. But you mentioned synthesized material earlier. AI-generated stuff. Senate Bill 20 tackles that deepfake issue. That sounds like a huge challenge for evidence.
It is. This is probably the most forward-looking and maybe the most challenging new law for digital forensics teams. PC 43.235, AI computer-generated material. It creates a state jail felony for knowingly possessing, promoting, or even accessing obscene visual material that depicts a child, someone appearing under 18, doing certain things. And here's the key part. It applies regardless of whether that picture or video is real, a cartoon, or an image created entirely by AI or other software.
Wait, if the image isn't even real, how does that change how you investigate possession? How do you prove criminal intent if it's all fake?
The focus has to shift. It shifts from proving a real victim exists to proving the intent and knowledge of the person who has it or is sharing it. Investigators need to show the material looks like a minor and that the defendant knew what they had or were accessing. Digital forensics might need to prove it's synthetic or that there's no real victim tied to it. Meanwhile, the investigative team proves the chain of custody, how the defendant got it, maybe how it was labeled or shared. Did they actively seek out material described as child exploitation? It massively expands what's considered illegal material. And it means you have to treat these non-real depictions just as seriously as real ones. It changes the whole proof model.
That's a major adjustment. Okay, besides defining new crimes, the legislature also added some new rights for victims that officers need to know about.
Absolutely. And these create specific duties for the responding officer. First, victim advocate presence under CCP Article 56A.3515, Senate Bill 761. Officers must now offer sexual assault victims the chance to have an advocate or an attorney present during an investigative interview. And this applies even if the interview happens outside the police station, say, at a hospital or a specialized center. You have to offer it and document that you offered it.
Okay, offer must be made. And there's something about anonymity, too.
That's right, Senate Bill 836. Officers responding to adult sexual assault victims have to inform them about their right to use a pseudonym, a fake name, in all public files and records about the offense. That's a really important protection, and the officer on scene has to actively tell the victim about it. Oh, and one more crucial procedural point. Emergency protective orders. Senate Bill 2196 extends their durations significantly. For family violence, sexual assault, stalking cases, they now last 61 to 91 days generally. And if a deadly weapon was used in a family violence assault, it's even longer, 91 to 121 days.
Good to know. Longer protection periods. Okay, let's shift gears to trafficking, organized crime, and misconduct. What's new with human trafficking laws?
Trafficking of Persons, PC 20A.0, Senate Bill 1212. This tackles a common defense tactic claiming ignorance about the victim. The law now explicitly states the offense is committed regardless of whether the traffickers knew the exact age of the child victim or whether they knew the victim was disabled. It simplifies prosecution. You don't have to prove the trafficker knew those specific details.
Removes a hurdle?
Exactly. Similarly, continuous promotion of prostitution, PC 43.032, House Bill 1778. That's now elevated to a first-degree felony if someone promotes prostitution 2 or more times over 30 days or more. Really emphasizes the seriousness of sustained exploitation.
And Texas is now tackling international crime with this transnational repression statute.
Yes, Senate Bill 1349. This creates new state offenses for transnational repression and also for unauthorized enforcement of foreign law within Texas. Now, this might be handled mostly by specialized units, maybe intel, but patrol officers should be aware if a foreign national acting for a foreign government is harassing, stalking, or intimidating someone in Texas, even if it's about politics back home, they could now be violating Texas state law.
Interesting. And for officers investigating public corruption or misconduct within agencies, the penalties for misusing official information got a lot steeper.
A lot steeper. Misuse of official information, PC 39.06, House Bill 2001. This was significantly enhanced with a tiered penalty system directly tied to how much money was gained. It applies to any public servant misusing official info for financial benefit. Penalties now start at a third-degree felony if the gain is less than $150,000. It jumps to a second-degree felony for gains up to $300,000. And anything over $300,000, that's a first-degree felony. It's a huge increase, clearly signaling zero tolerance for this kind of corruption.
Wow, yeah, that sends a message. And penalties for staff bringing contraband into jails or prisons also went way up, especially if someone dies.
Extremely high now. Contraband in correctional facilities, PC 38.11, House Bill 3464. It's now automatically a second-degree felony if a facility employee provides alcohol, drugs, controlled substances to someone in custody. But the stakes get incredibly high. If giving that substance causes the inmate's death, the offense immediately becomes a first-degree felony, a clear, strong deterrent against staff compromising facility safety.
Okay, let's talk theft, fraud, and digital crime.
Yeah.
We hear the term jugging, a lot of people, following bank customers. Now, there's a specific law for it.
Yes, and it targets the attempt stage, which is key. Jugging, PC 29.04, House Bill 1902. This creates a new state jail felony. It applies if someone knowingly travels the same path as a person leaving a bank or business while possessing 2 or more criminal instruments, and they intend to steal that person's money.
Okay, so let's say an officer sees a car clearly following someone from an ATM. They pull it over, find masks, maybe a window punch tool. What does this law allow?
It allows the officer to potentially arrest and charge based on that observed conduct the following, combined with the possession of those tools, plus the inferred intent to commit theft. You don't have to wait for them to actually break the window or rob the person. It recognizes the pattern of these organized crews and gives you probable cause for the felony based on the preparation itself. That's a really useful tool.
Definitely. And we also see new laws targeting metal theft and those skimming devices.
Right. Unauthorized possession of copper brass, PC 31.22, Senate Bill 1646, creates new specific offenses targeting possession of certain types of copper or brass without authorization. Still a big problem for infrastructure theft.
And on the digital side, skimmers. Always a battle. Looks like a 3-part attack on them.
Pretty much. First, gift card fraud, PC 32.56, Senate Bill 1809, creates a specific offense for messing with gift cards, the packaging, the data, with intent to defraud. Tackles that growing retail fraud angle. Second, and this is really important for searches, Senate Bill 1497. It clarifies that those wireless devices known as skimmers, the ones used to steal card data, are now specifically excluded from the general rule requiring a warrant for tracking devices under CCP Article 18.0215. gives clear authority, treating skimmers like the high-priority criminal tools they are.
Okay, so easier to track or seize. And the third part puts some responsibility on businesses.
Exactly. This is under the Business and Commerce Code, Chapter 607A, Senate Bill 2371. If a service tech or their employer finds a skimmer on something like a gas pump, they are now required by law to report it to law enforcement. And there are now criminal penalties if someone refuses to let law enforcement inspect a terminal they suspect has a skimmer, or if they recklessly get rid of a compromised terminal before it can be checked. Creates a direct pipeline of intel for investigators.
Good, closing that loop. All right, let's shift to the day-to-day operational stuff. Arrest authority, detention, officer safety, things that directly impact your workflow.
Right. These are the practical procedural updates, starting with efficiency. DWI blood warrants, CCP Article 18.067, Senate Bill 1886. Recognizing that blood alcohol evidence is time-sensitive, the law now says a warrant to collect blood can be executed by any peace officer in the county where it was issued, or in any adjacent county. Expands the reach, which is helpful especially near county lines.
Okay, more flexibility there. Another big one for patrol is handling emergency mental health calls. Officers often get stuck waiting at hospitals or facilities for hours.
Yeah, that procedural bottleneck gets addressed by Emergency Mental Health Apprehension, Health and Safety Code 573.001, Senate Bill 11164. Officers still have the authority to take someone into custody without a warrant if they meet the criteria: mental illness, danger to self or others. The big operational win here is the officer is now authorized to leave the facility immediately after the person is safely in the custody of the facility staff, and the required emergency detention paperwork is filled out and handed over. Huge time saver to get officers back on the street, but you must use the updated, correct emergency detention forms specified in the law.
Got it. Use the new form, hand off custody, get back in service. Okay. What about dealing with sexually violent predators who are under civil commitment?
New authority there, too. Sexually violent predators, CCP Article 14.03, Senate Bill 1610. Officers now have explicit authority to arrest without a warrant anyone they have probable cause to believe committed a new felony while they were under that civil commitment as an SVP. These individuals are considered high risk, so this gives officers an immediate tool if they violate their commitment terms by committing another serious crime.
Okay. And a quick note on paperwork, the fee for serving warrants went up.
Minor detail, but yes. The fee reimbursed to an officer or agency for executing or processing an arrest warrant or CIPIAs is now $75. That's CCP 102.011.
Okay. But the next procedural requirement you said is not minor. It's about the information officers give the magistrate when someone's arrested, especially in family violence cases.
This is critical. Arrestee reporting requirement, CCP Article 14.06, Senate Bill 1896. The arresting officer is now legally required to provide the magistrate with all relevant information about the arrestee specifically for issuing an emergency protection order. It puts a direct duty on the arresting officer. You have to gather and relay comprehensive details about the defendant, the incident, the victim, and you have to use the standardized forms from the Office of Court Administration. The goal is to get that protective order issued right away at the initial magistration.
Makes sense. Get the protection in place faster.
Right.
Okay, let's talk about legal protections for officers, especially around use of force.
Right. Use of less lethal force weapon, PC 9.55, Senate Bill 2570. This creates a specific defense to prosecution for correctional officers and peace officers who use less lethal force while doing their job. The key phrase, though, is they must be acting in substantial compliance with their training.
So that defense really depends on the department having solid, up-to-date training and documenting it well, right?
Absolutely. It's both a shield and a mandate. It protects the officer who acts reasonably according to their training, but it puts the burden on the agency to make sure that training is current, comprehensive, and meticulously documented. Your defense hinges on proving you followed that established standard.
Okay. There's also a clarification about deadly conduct charges.
Yes. Senate Bill 1637 amends deadly conduct, PC 22.05. It clarifies that the usual legal presumption of recklessness and danger when someone discharges a firearm doesn't automatically apply to a peace officer who is lawfully doing their official duties. If an assaultive offense is alleged related to discharging a weapon, the law says it just doesn't apply if the officer was actually performing official duties or reasonably believed the discharge was justified. Provides a clearer legal defense in those situations.
Good clarification. And finally, some new protections for other public servants, utility workers, court staff.
Right. Utility Employee Protection, PC 38.15, Senate Bill 482. Utility workers are now officially included in the list of people protected from interference while doing their public duties. Assault or harassment against them carries enhanced penalties now. And, importantly, Judges, court clerks, and certain other court employees are now designated as at-risk individuals under Government Code, Chapter 92, House Bill 50801. This makes it a specific criminal offense to intentionally post their personal identifying information online if the intent is to cause them harm. Extends that privacy protection to keep judicial staff and their families safer. Oh, and one small update for retired officers. Retired officer IDs, GC Section 614.124 HB 3686. Those ID cards for honorably retired and qualified retired officers must now include the position or rank held at retirement.
Okay, got it. Now, let's tackle the big one. The one that's probably going to cause the most immediate headaches on the street starting July 1st, 2025. The complete overhaul of temporary vehicle tags under House Bill 718. You said this is massive, aimed at killing the fraudulent paper tag market.
It is massive. And yes, the goal is admirable. Texas was drowning in fake paper tags, made traffic stops incredibly difficult, So HB 718 basically throws out the old system. It eliminates 6 common paper tags and permits entirely. Gone are buyer's tags, the internet down tags, one-trip permits, 30-day permits, dealer agent tags, and those dealer vehicle-specific tags.
6 types of paper just gone. What takes their place?
4 new types of metal license plates. And the law forces dealers onto the centralized web dealer system for all their title and registration stuff. They also have to submit a vehicle transfer notification, or VTN, electronically right when they sell the car. The whole idea is shifting from easily faked paper to standardized metal plates issued immediately by the dealer.
Let's break down the plates officers will see. The main one replacing the paper buyer tag is the general issue metal plate. How does this work at the dealership, and what will officers see on the road after July 1st?
This is the fundamental change Patrol needs to grasp. Starting July 1st, when someone buys a car, the dealer gives them 2 general issue metal plates, right there at the sale. But here's the critical difference. The customer drives off the lot without any registration sticker on the windshield. The metal plate itself serves as the temporary registration.
Okay, hold on. So I pull over a car on July 2nd. It has a brand new, clean metal plate, no sticker. How does the driver prove it's legit, and how do I check it?
The driver is required to keep the buyer's receipt from the dealer in the vehicle. Glove compartment, ideally. That receipt proves they just bought it. The actual registration sticker, that won't come until later, maybe weeks later after the title application goes through the county via web dealer. The plate is valid during that whole processing time, so the enforcement changes. You're not looking at the windshield first. You're running the plate in TLET SNLETs immediately, and you're asking for that buyer's receipt.
Okay, run the plate, ask for the receipt. But this leads right to the big potential snag, the internet down scenario. The law actually mentions this. What happens if the dealer system is offline?
This is where things could get tricky, especially in the first few months. If the dealer's internet is down, or the state's web dealer system is down, they still issue the general issue metal plates, and they give the customer a paper receipt form. But, and this is the key, the buyer's information won't be sent to TXDMV right away, which means it will not show up in TLETs or NLETs immediately.
So I run the new plate, it comes back not found or unassigned.
Oh.
But the driver has this official-looking receipt. What's the rule? Is there a grace period? What should I do?
There is a statutory grace period. The dealer has 24 hours to get that buyer info into the ePlate system once the system is back online. This means officers need to use caution and judgment in that window. If the driver has a buyer's receipt that looks legitimate for that new metal plate, you have to consider this TLEC-TS lag is possible. If you strongly suspect fraud, okay, you can detain to try and verify the dealer info on the receipt, maybe call them if possible. But making an immediate arrest just because the plate isn't found during that potential lag period, that could be problematic. Training on this is crucial.
Definitely sounds like it. Okay, what's the second important new plate? The dealer temporary plate. What replaces the old dealer tags?
Right, the dealer temporary plate. This replaces the old vehicle-specific tags and the dealer agent tags. Its use is strictly limited to business purposes. Moving cars between dealerships, going to auction, to the mechanic, using it on a loaner car, or for a customer test drive. That's it. It absolutely cannot be used for the dealer's personal errands. And it cannot be used to carry a load unless that load is another vehicle with plates that's being transported for sale.
And enforcing misuse is stronger now. What about people making fake metal plates?
Yes, the law specifically sets out new criminal penalties for misusing these plates. That's in Transportation Code 504.944 through .946, and it includes a potential third-degree felony charge for anyone caught making, selling, or even just using a deceptively similar license plate trying to look like one of the new official ones. Gives LEA much more power to shut down the fraud rings making fake plates.
Good, more teeth there.
Okay.
Besides the huge plate overhaul, any other notable transportation code changes? Right-of-way, public records.
A couple of key things. Senate Bill 2039 updates the right-of-way for sidewalk users, TTC Section 541.001. It expands the definition of sidewalk users. Now includes people legally riding bicycles, scooters, skateboards, roller skates on the sidewalk. These users now legally have the same rights of way as pedestrians at crosswalks and stop signs. Drivers have to yield to them. Subtle, but important for traffic enforcement.
Okay, yield to scooters and bikes on sidewalks or crosswalks. Got it. And some about license plates and videos.
Yeah, this clarifies things for public information requests. House Bill 1893 addresses license plate confidentiality. TTC Section 730.007. It explicitly states that license plate numbers captured in videos like dash cam or body cam footage are not considered confidential records anymore. Agencies used to spend a lot of time redacting plates before releasing videos. That requirement is gone now. Should streamline releasing footage when requested.
Okay, simplifies that process. This has been a really dense briefing. We've covered a huge amount of ground, impacting everything from basic procedure to complex investigation.
It's a lot to absorb, absolutely. The volume and the specificity of these changes mean departments really need to act now to get this information out.
Let's quickly recap the absolute top 3 things demanding immediate attention, the highest risk areas.
Okay. First, without a doubt,
Yeah.
the sworn oath requirement from Harbridge. Stop relying on just a signature on the affidavit. Mandate that formal verbal affirmation. Document it every single time. It's constitutional.
Verbal oath. Number 2.
Second, the electronic harassment shift from Owens. Retrain immediately. Focus reports on criminal lag. Conduct the pattern, the persistence, the timing, the victim's attempts to stop it. Not just quoting offensive words. Document the behavior to make your case stick.
Conduct over content. Got it. And number 3.
Third, the transportation overhaul, HB 718, starting July 1st. Prepare for confusion with the new metal plates having no stickers. Understand and train patrol on that potential 24-hour TLATS lag when the internet's down. Emphasize checking the required buyer's receipt.
Okay. Oath, harassment conduct, and the new plates of the TLTS lab. Those are the immediate action items.
Absolutely. Getting these things wrong means warrants get thrown out, cases get dismissed, and perfectly valid stops might get challenged. Incorporating these shifts right now is essential.
And looking at the bigger picture of all these changes, the new consent definitions focusing on what the actor knew, the heavy penalties for corruption, and especially criminalizing AI-generated child exploitation.
It really signals a massive acceleration, doesn't it? The need for specialized skills. Digital forensics, financial crimes expertise, understanding AI. It's becoming central to so much of the penal code.
Which leads to a final thought, maybe something for you to consider back at your agency. With technology now so deeply woven into criminal law, AI crimes, digital currency, rapid DNA, how quickly can your agency truly operationalize all this? How fast can you adapt your training, your tools, your expertise to effectively use these new laws and stay ahead of criminals who are definitely using the tech?
That really is the challenge, isn't it? Staying ahead in this landscape.
It is. Thank you for joining us for this deep dive into these crucial updates. Stay safe, and we'll catch you on the next one.